When you buy a condo in Ontario, there's one thing that every buyer should do, and that's review the status certificate. Virtually every condo offer includes a condition for this. The buyer's lawyer gets a few days to look it over, give that information to the buyer, and put them in a position to make an informed decision. In this video, we're going to walk you through what a status certificate review actually involves, what your lawyer is looking for, and how the condition works in a real transaction. My name is Zachary Soccio-Marandola. I'm a real estate lawyer here in Toronto, and I help people like you close real estate deals every single day. So let's start with what a status certificate actually is. Let's start with the basics, because there's a lot of confusion here. A status certificate is a document that a condo corporation is required to provide under the Condominium Act. Any person can request one. The corporation has 10 days to produce it, and the fee is capped at $100, including tax. But here's what most buyers don't realize. The status certificate document itself, that's Form 13, is about 5 pages long, and that has specific information about the unit. What comes with it is a full package: the corporation's declaration, bylaws, rules, the current budget, the most recent audited financial statements, notice of future funding, insurance certificates, etc. So there's 2 parts to every status certificate package: the status certificate itself, that's the one specific to the unit, and the other documents that relate to the corporation as a whole. Your lawyer needs to review both parts together to get the full picture, what your lawyer is actually looking for. Let me walk you through what a proper review actually involves. There are 3 areas that I focus on in every status certificate I review. Number 1 is a legal description and condo plan. This sounds administrative, but it matters more than people think. The condo plan is a registered document that defines the boundaries of your unit, what's yours, what's common element, and what falls in between. When I'm reviewing, I'm checking that the unit boundaries match what's being sold, that the parking space and locker are properly reflected, and critically, whether they're owned units or they're exclusive use or common elements. That distinction is not just terminology. An owned parking unit is registered separately on title, so you own it. You can sell it or lease it independently. An exclusive use common element is tied to your unit. It's assigned to you, but the corporation retains ownership. You cannot deal with it separately. So in a real transaction, I've seen agreements drafted without this being clarified, and buyers closing without knowing whether they actually own their parking space or not. The status certificate and the condo plan are where that gets confirmed. There are also rules in the declaration and bylaws about how your unit can be used. That can include short-term rentals, pets, renovations, leasing requirements, if you plan to rent the unit as an Airbnb or run it as an investment, or, for example, put in hardwood floors. Those answers are in the package. And once you close, you're bound by them. Number 2 is common expenses, reserve fund, and future funding recommendations. Common expenses are your monthly maintenance fees, the amount you contribute towards the operation of the building. The status certificate confirms what those fees are to your specific unit and whether the seller is currently in arrears. Arrears matter because unpaid common expenses become a lien against the unit. If that lien isn't cleared before closing, well, it becomes your problem. But the bigger financial piece is the reserve fund. The reserve fund is money the corporation sets aside for major repairs and replacements, things like roofs, elevators, parking structures, windows. It's not discretionary. Ontario law requires every condo corporation to maintain one and to conduct a reserve fund study at least every 3 years. Here's the critical part. I'm not just looking at how much is in the reserve fund. I'm comparing that number to what the study says it should be. The actual number of the reserve fund at the time of the status certificate is not that helpful. Condos are different sizes, they differ in number of units and amenities, and it's tough to say from the number alone whether or not it's adequate. So more importantly, we're looking to confirm that the corporation is following the funding recommendations of the reserve fund study. If the study says that the fund should be at a certain level and it's significantly below that, there are 2 ways that that gap gets closed. The corporation either increases its contribution, which means your monthly fees go up, or it levies a special assessment. Now, a special assessment is a one-time charge on top of your regular monthly fees. And here's something a lot of people don't know. The board can levy a special assessment without owner approval. There's no vote, there's no veto, the board passes a resolution, and the bills go out. So what I'm looking for in the status certificate is whether any assessment has been approved, or if there are any indications that one might be coming. The third thing we're looking at is litigation. The status certificate also discloses whether the corporation is involved in any outstanding legal proceedings, both as a plaintiff or as a defendant. Now, not all litigation is a red flag. Context matters a lot here. So a corporation suing a contractor for construction deficiencies is very different from a corporation defending a personal injury claim. I'm looking at the nature of the action, the potential financial exposure, and how it might affect the unit owners. If the corporation loses a significant lawsuit and doesn't have the reserves to cover it, that cost flows down to the owners through either increased contributions or through a special assessment. So legal descriptions, reserve fund, and litigation, those are the three main areas of every status certificate review I do. How the condition works in a real transaction. Now let's talk about the mechanics, because there's some confusion around how the condition actually works. When an offer to purchase a condo is drafted, it typically includes a condition. Here's an example of a common one. This offer is conditional upon the buyer and the buyer's lawyer reviewing the status certificate and attachments and finding the status certificate and attachments satisfactory in the buyer's and the buyer's lawyer's sole and absolute discretion. The seller agrees to request, at the seller's expense, the status certificate and attachments within 10 days after acceptance of this offer, unless the buyer gives notice in writing to the seller, personally or in accordance with any other provision for delivery of notice in this agreement of purchase and sale or any schedule thereto, not later than 11:59 p.m. on the third day, excluding Saturdays, Sundays, and statutory holidays, following receipt by the buyer of the status certificate and attachments that this condition is fulfilled, then this offer shall be null and void, and the deposit shall be returned to the buyer in full without deduction. This condition is included for the benefit of the buyer and may be waived at the buyer's sole option by notice in writing to the seller, as aforesaid within the time period stated herein. So I know that's a lot, but let's break it down. So it's common for the seller to request and pay for the certificate and then deliver it to the buyer. Once delivered, the clock starts ticking, usually 3 to 5 business days for the review, but this is all negotiable. This creates a timing pressure that catches a lot of people off guard. This means hiring a lawyer becomes a very early step that as a buyer you need to take care of. Having one retained and ready to review the status certificate as soon as it comes in becomes very important. Once the status certificate is received and your lawyer completes the review, there are two outcomes. If the review is satisfactory, the condition is fulfilled and you do that by confirming in writing that you're proceeding, the deal then goes firm. If the review reveals a material concern, you have a decision to make. You can go back to the seller to negotiate, you might ask for a price adjustment, ask that an assessment be cleared before closing, or seek additional representations. Or if the issue is serious enough, you can rely on the condition to walk away. One important point, a status certificate is only current as of its date of issue. If a seller's pre-ordered a status certificate and it's already 2 months old when you receive it, that won't be the best document to use for your review condition. That's the value of the condition itself. It's not a formality, it's a mechanism that gives you an informed exit. If you waive it or skip the lawyer review to move faster, you close on whatever's in that package. And the corporation is bound by what is disclosed, but you're bound by everything that comes after. The status certificate review is one of the most substantive things a real estate lawyer does on a condo transaction. It's not a checkbox, it's a due diligence exercise on the financial and legal health of a building you're about to become an owner of. The practical takeaway: include that condition in your offer and give your lawyer enough time to actually receive and review the package fully. If you remember one thing, remember this. You're not just buying a unit, you're buying into a corporation. The status certificate review is your chance to understand as much as you can about that corporation before committing. If you're enjoying these behind-the-scenes real estate law videos, be sure to subscribe to the channel. I post a new video every single week. And if you're in the industry, I also send out a weekly newsletter with practical legal info written specifically for realtors. The link is below in the description to that. Thanks for watching.